Hi, everyone. Welcome to the webinar. My name is Sarah Weeder, and I'm going to be acting as a host for today. We are so excited to have Shannon O'Keefe with us. She is going to be presenting on the classification of properties in divorce and legal separation cases. We are so lucky to have her here. As always, your participation and attendance is completely anonymous. So feel free to ask any questions. You can type them into your chat box and we will have a question and answer session at the end of the webinar. So without further ado, I'm going to go ahead and hand it over to you.
All right, thank you so much, Sarah. I'm going to share my screen here and I'll ask you before we jump in, can you see my screen okay? Is it presenting properly?
Yep, looks good.
Okay, awesome. Well, welcome everyone to today's webinar where we will be discussing the classification of property and dissolution of marriage cases and legal separation cases. Please note that this presentation does not constitute legal advice. However, I am very happy to have you all here and I'm excited to dig into this topic. So let's get started. We're talking about generally when we're mentioning classification of property, we're thinking of marital property versus separate property. All property owned by both spouses will fall into either the marital property bucket or the separate property bucket. The court's first job is to sort the property between these buckets, and then the court can get down to the business of dividing or allocating marital property. Marital property is defined as all assets accrued and debts incurred by either spouse from the date of marriage until the date the court enters a decree of dissolution of marriage or a decree of legal separation, regardless of in whose name the asset or debt is titled or listed. Some common questions when we're dealing with the definition of marital property and we're talking about separate property. Number one being, what if my spouse and I end our romantic relationship and we physically separate? What effect, if any, does that have on the definition of marital property? The answer is it does not affect at all the definition of marital property. For example, if spouse 1 or S1 moved out of the marital home 10 years ago, but the parties remained legally married, i.e. there's no decree of dissolution of marriage or a decree of legal separation, and spouse 2, after the physical separation, buys a house of her own, that residence will still be classified as marital property, which is subject to division or allocation by the court if either spouse later files for divorce or separation. So it's still going to be marital property, even if you in your mind think it's not your other spouse's, even if your spouse thinks this is not my property, the court is going to have to apply the law, which is that it's going to be classified as marital property. Another common question is, of course, are there exceptions to the marital property rule? And it's the law, so there's always an exception. And here we have 4 that are specifically outlined by statute. The first exception is that property acquired by gift from third parties or by inheritance will not be marital property. So, for example, if your sister gives you a gold coin during your marriage, that gold coin will not be marital property. Same if your sister were to pass away during your marriage and leave you the gold coin. If the gift, however, is a gold coin, let's say to continue our example, from your spouse, then the presumption is that that coin is still marital property. So just note that this exception does not apply to gifts between spouses. The second exception here is property acquired in exchange for property owned prior to the marriage or in exchange for property acquired by gift or inheritance. So this exception actually covers 3 scenarios. Number 1, if I own the gold coin prior to marriage, if I'm gifted the gold coin by a third party during my marriage, or if I inherit the gold coin during my marriage. In those situations, if I trade in the gold coin for, let's say, I don't know, how much is a gold coin worth? We'll say we're trading it in for an entertainment system. Then that entertainment system would continue to be my separate property, not marital property. And that's because I obtained it in exchange for separate property. The third exception here is property acquired by a spouse after a decree of legal separation. If a court actually issues an official decree of legal separation and you go out and purchase a gold coin afterward, that gold coin will still be your separate property, even if your spouse later asks the court to convert the decree of legal separation to a decree of divorce. The last exception here is property excluded by a valid agreement of the parties. Commonly, people think of premarital agreements or prenups. These can also be postmarital agreements. In that case, if either, any, I guess, of these exceptions apply, the effect is that the property is deemed separate rather than being classified as marital. Another common question is, what about property I owned prior to marriage? The answer here is it depends. The court could classify it as marital property. The court could classify it as separate property. If the property has decreased in value or the value has remained the same since the date of marriage, then the entire value of that property is the original spouse's separate property in a divorce or legal separation proceeding. If the property has instead increased in value, then the amount of the increase could be marital property. The premarital value, however, would remain the originating spouse's separate property. So let's look at some examples. For example A, S1 or spouse 1 purchased a Honda prior to marriage. As of the date of marriage, the Honda has a value of $10,000. As of the date of the decree of either legal separation or dissolution of marriage, the value is $2,000, so it's decreased in value. Assuming that title has always remained solely with spouse 1, the Honda and its associated value will be S1's separate property in the event of a divorce or a legal separation. So that's our example where it's decreased in value. For example B, S1 owned a retirement account prior to marriage. As of the date of marriage, the balance was $200,000. As of the date of the decree, the balance is $300,000. So it's increased in value about $100K. That increase in value of $100K is marital property. The $200K premarital balance would be separate property. So just remember, increases in value, if they're accrued during the marriage, it's going to be marital property that's subject to division. Another common question that people might ask is, what about debt incurred prior to marriage? It depends, of course, again, generally so long as the debt has remained in the original spouse's name solely, the debt will continue to be that spouse's sole responsibility following the entry of a decree. There is an exception if the debt is refinanced or otherwise placed into both spouses' names. And we have a good reason for that. We're going to introduce a wrinkle here called transmutation. So it's a curveball into our relatively straightforward examples thus far, and it's got a really funky name. But what it means is that it happens when separate property owned by one spouse becomes marital property by some affirmative action of the parties. And there's a couple common ways that transmutation can happen. One common way is there is a retitling of an asset or refinancing a debt that used to be in S1's name, but you're doing it now into both S1 and S2's joint names. So for example, S1 purchases a home prior to marriage. As of the date of marriage, the value of the residence is $400,000. 2 months after the marriage, the home is retitled in S1 and S2's names jointly. As of the entry of the decree, the home is worth $500,000. The effect in this scenario is that the entire $500,000 value is going to be classified as marital. The premarital or separate value is deemed a gift to the marriage by virtue of S1 retitling the home into S1 and S2's names jointly. So we have transmutation. This formerly separate property asset has transmuted into marital property. Another common way for transmutation to happen is if there's a change in the balance of savings and checking accounts. So for example, S2 owns a Chase savings account prior to marriage. As of the date of marriage, the balance is $25,000. The parties file for divorce 10 years later, at which time the balance of the account is $100,000. And during the marriage, there were innumerable transactions with both parties having access to the Chase account. So they're both spending out of it. They are both contributing to it. The effect of this sort of intermixing of funds and allowing of access is that the entire $100,000 balance is likely to be deemed marital, as there's no way for the court to accurately trace trace which dollars are marital and which are separate. We had that $25,000 in the account at the beginning, and obviously we've had a change in the balance. The court can't say that that same $25,000 that was in the account at the start of the marriage is the same $25,000 that is part of the account at the end of these parties' relationships. So we have a tracing problem. The court's just going to say, okay, we can't figure it out. There's no way for us to track these dollars down. So it's all going to be marital property that's subject to division. Some people might ask, what's the scope of the court's authority with regard to marital and separate property? What exactly can the court do after it's been classified in one bucket or the other? Under CRS, Colorado Revised Statutes 1410-113, the court shall set apart to each spouse his or her property and shall divide the marital property without regard to marital misconduct in such proportions as the court deems just after considering all relevant factors. So the first underline here refers to separate property. The second and third underline here refer to the court's authority with regard to marital property. So with regard to the division or allocation of marital property, the court is required to divide it or allocate it equitably. In determining what's equitable, the court has to consider a number of factors that are outlined by statute. It's just a little bit outside the scope of our discussion today, but generally what is fair may be a 50-50 division of marital property so that each spouse is allocated an equal net value. Other times, given the circumstances of the parties, especially if there are exigent circumstances, like one spouse has medical conditions and can't work, can't support themselves. There's a number of other exigent circumstances that court could consider. But given the circumstances of the parties, it may be fair to have an unequal, so not a 50-50 division of marital property. It's going to depend on the facts of your specific case. With regard to separate property, you might ask, well, can the court divide my separate property so that my spouse gets some or all of the value? The short answer is no. Your spouse cannot claim any portion of your separate property. The court does not have the authority to allocate it or divide it. It only has the authority to set it aside to the party who owns it as separate property. However, there's always an exception. The court is permitted to consider the net value of the separate property apportioned to you when determining how to fairly divide the marital property. What does that look like? Let's go through an example. Here are our facts. S1 purchased a home prior to marriage. The value as of the date of marriage was $2 million. As of the entry of the decree, the home is worth $2.1 million. So there's an increase in value of $100,000. During the marriage, the residence remained in S1's name only. S2 was never added to the title. S2 has no responsibility for the mortgage directly, so there's no transmutation. In this case, then, the $100,000 increase in value is marital property, and the $2 million premarital value is S1's separate property. Because S1 will likely be entitled to the $2 million premarital value, the court may determine that it is fair to award a greater percentage, so something more than 50% of the $100,000 increase in value to S2 in order to attempt to place the parties on more even footing post-divorce. So the court is considering the fact that S1's got $2 million, and maybe if this is the only asset, maybe the only marital property is this $100,000. So you're looking at $2 million versus $100,000. The court can't make it equal, but it can make it more fair than dividing up this $100,000 50-50. So spouse 2 only gets $50K, and then spouse 1 is walking away with $2 million plus $50,000. Doesn't feel very fair. Doesn't feel very equitable. So that concludes the prepared presentation on classification, determining which bucket your property is going to fall into. I know that we went through some common questions and a few examples, but I'm happy to at least attempt and answer questions that anybody might have. If anyone submitted some, Sarah.
Thank you so much, Shannon. So I don't see any questions, but I do have someone asking to go back to the third slide.
Okay, let me see if I can figure out how to do that. Bear with me. I think I'll have to go through all of them. 1, 2. Okay, I'm assuming that we're not counting the first 2 slides in determining which is slide 3. So I'm going to go back to the beginning all the way, and then I'll count forward. Okay, so this is slide 1, 2, 3. Is this the right slide that they're asking for?
Yes, this is correct.
Okay, so I can explain this a little bit more in detail. Essentially, how you have it in your mind about your relationship with someone you're married to doesn't affect how property is classified. So even if you and your spouse agree that, hey, informally, I'm going to move to Arizona, you're going to stay here in Colorado, I'm going to go buy myself a new house, and we're just not going to continue our relationship with one another. We're going to live separately and apart for the rest of our lives. That's not enough for the law to say that whatever assets you accrue or whatever debt you incur during that time of physical separation is not going to be classified as marital property. So there are risks here in two different ways. If spouse two purchases a house 10 years after physical separation, but there's no decree of dissolution of marriage or legal separation, then that asset could be subject to division or allocation. On the flip side, you have risks with regard to debt. If spouse two has a gambling problem or some other spending issue, and they rack up enormous amounts of debt, if you're still legally married, well, creditors can still come after you as the spouse. And if either of you file a petition for dissolution of marriage or for legal separation, then the court has to look at those debts as marital because they were incurred during the marriage. There are, of course, things that the court can do when allocating things. It doesn't mean that the court has to do a 50-50 division. We always have the court considering your circumstances. So maybe if spouse number two racks up $2 million worth of debt, the court's going to say, is it fair for me to give S1 responsibility for a portion of that debt? Probably not. You probably have a good argument to protect yourself, but it's a risk. And when the judges have this almost unlimited amount of discretion when dividing property, the term equitably is very broad. So as long as the court can give a good reason for what they think is fair, basically that's going to be upheld. So you have a level of risk by not just getting a decree of divorce or a decree of legal separation to protect you. I know you didn't ask a specific question, person who wanted to see this slide, but maybe that clears things up a little bit.
Thank you so much, Shannon. That was perfect. So I'm not seeing any other questions, but I do want to let everyone know that you can ask any questions that you want. If you want to speak with Shannon personally, feel free to give us a call. You can also send us an email to info@johnsonlgroup.com, and we can connect you with whoever. We can answer any specific questions that you have, and we can also set up a free consultation if you have any questions about your specific case. But I did want to thank everyone for registering and attending. These webinars are becoming sort of a series for us. So check out our Facebook and Instagram, LinkedIn, and you can stay up to date with all the webinars that we have coming up. We have quite a few coming up. So thank you again, Shannon. We really appreciate you taking time out of your day for this. And I hope to see everyone at the next webinar.
Thank you, Sarah.